Olá, esse é o Poder Entrevista. Eu sou Paulo Silva Pinto, editor sênior do Poder 360.
Eu sou Léo Garfinkel, jornalista do Poder 360. Vamos entrevistar Joan Barata, pesquisador da Universidade Vanderbilt. Joan Barata tem 53 anos. É pesquisador do think tank Future of Free Speech, Futuro da Liberdade de Expressão em português, na Universidade Vanderbilt, nos Estados Unidos. Joan Barata, thank you for accepting the invitation for this interview.
Thank you. It's a pleasure to be here.
Agradeço também a todos os web espectadores que assistem este programa. Esta entrevista está sendo gravada no estúdio do Poder 360 em Brasília, em 15 de abril de 2025. A entrevista, a partir de agora, será em inglês. What is your assessment of free speech today as compared to 5 years ago or 10 years ago?
I think that in general, from general perspective, and if we look into the different regions of the world, there has been some degree of deterioration when it comes to freedom of expression. First of all, because the number of journalists that are being killed in different conflicts, the journalists that are being harassed, prosecuted in different parts of the world has only increased. But not only that, I think that governments are increasing the pressure using legal and regulatory instruments. We see more and more laws being adopted, more power being given to regulatory bodies, to different to prosecutors, to law enforcement, in the name of very vague and open concepts like cybersecurity, preserving the public order, avoiding public disturbances, so on and so forth. So I think, and it's not only my impression, I think that the most relevant international bodies in the field of human rights and freedom of expression have also been underscoring that the tendency is that freedom of expression and protection of freedom of expression, even in countries that are considered to be liberal and democracies, has been deteriorating.
Yeah. What about the case of Brazil? You have an assessment of the situation of free speech in Brazil in the same time span as you considering as you considered in the previous answer?
No, I think that what I can say about Brazil is that Brazil has a very interesting instruments to protect freedom of expression. It has, I think, a solid constitution. It has good case law when it comes to the Supreme Court and the courts in general. In the field of freedom of expression, you have vibrant media environment, and when it comes to the online world, and I'm sure we'll be talking a little bit more about this, but you have the Marco Civil de Internet, which is, I think, a remarkable piece of legislation. It was adopted almost a decade ago, and I think it is still valid, and I think it helped a lot to protect freedom of expression in this country. Of course, in all countries there are issues. And it is it's been reported by civil society organizations and even international bodies that there are issues of let's say media concentration that still need to be addressed. Of course, in the online world there are also abuses. There's still some uncertainty in how to properly deal with that. So, of course, no country is perfect in this sense, but I think that at least Brazil counts on very relevant checks and balances when it comes to the adoption of decisions affecting the right to freedom of expression.
Okay, Professor, speaking of Brazil, what's your assessment of decisions made by the Supreme Court and the Electoral Superior Court during Brazil's 2022 presidential election?
Yeah, I think that, let's say, the first thing that I have to say as a lawyer, and we all lawyers say, and I'm sure that some people don't like that, but I don't like to talk about decisions that I haven't read in full, let's say, no? So because court decisions are always very technical and they're based on national law, and I'm not an expert in Brazilian law. So that's the first thing I need to say. I think that also in the case of the regulation of elections and obligations for online platforms, for example, I think that there's this tendency, or perhaps this temptation sometimes to over-regulate, let's say, no, and to, in the name of very, say, of good principles, no? But there's this tendency sometimes to try to prevent things before they happen through regulations that perhaps may go a little bit too far in terms of the details that they establish, so on and so forth, no? But I know, every single election process, particularly in a big country like Brazil, in a country where there's some degree of polarization, are always sensitive, no? On the one hand, there's the willingness to protect the democratic process, to make sure that that harmful content is not disseminated to an extent that becomes unbearable to handle. But on the other hand, of course, there's the concern that an excess of regulation, an excess of cautions may also affect the right to freedom of expression and introduce restrictions that might be excessive. No, and I think that Brazil at this point is facing this kind of dilemma and is trying to find a balance. And often it is not easy to find this balance. In general, I have to say that the case law, as I already mentioned, the case law of the Supreme Court is solid in terms of freedom of expression, and it is remarkable in this sense. No, but I also understand that there's a lot of pressure coming from many different sides when it comes to the decisions that may affect the exercise of the right to freedom of expression, particularly within the context of an election or very sensitive context of an election.
Now, judges in Brazil have been ruling that freedom of speech cannot be used to harm other rights as people's honor.
Yeah.
What's your opinion on this?
Well, this is not only something that you can find in the Brazilian constitution or the Brazilian, let's say, legal system, but this is also something that you find in the international and regional human rights system. No, you have freedom of expression that is protected by international law, and according to Article 19 of an international treaty that is called the International Covenant on Civil and Political Rights, and Article 13 of the American Convention on Human Rights, you have the protection of the right to freedom of expression, but also certain limits to the right to freedom of expression. So that's true. Freedom of expression is not an absolute right. Freedom of expression has limits, but we also need to understand something that I say quite often is that limits also have limits. You cannot impose any limit to the right to freedom of expression. As a state, when you limit freedom of expression, you need to respect also certain limits. For example, restrictions must be very clearly established by law. They need to kind of have a legitimate purpose and need to be necessary and proportionate. So, for example, you're talking about reputation, no? In some cases, of course, if something that is expressed is completely false, and there's let's say, malice from the side of the person who speaks, the journalist or someone else, of course, in that case, we need to give more weight to the right to reputation. But if at the same time you are expressing political criticism, you are expressing a political opinion, very strong political opinion, which might sound even offensive, but it's a strong political opinion, for example, or you are reporting about a case of corruption that is clearly a case of corruption, then the right of freedom of expression should prevail. We need to understand that in many circumstances, the right to freedom of expression prevails vis-a-vis other rights, because that's the general principle, because the right to freedom of expression is particularly connected to the democratic principle. And this is why, in many contexts, and this is the case law, for example, of the Inter-American Court of Human Rights, freedom of expression, the right to freedom of expression needs to be given prevalence vis-a-vis other rights. Of course, this is not absolute. There will be some cases where, in order to protect the reputation against unfair attacks, we will need also to protect reputation. But what I always say is that freedom of expression is the general principle. Restrictions are only the exception. And this is the way we need to look at it.
And how is Brazil doing vis-a-vis those limits of limits? Is it good enough, or should it be better?
There's always room for improvement. For example, you still have defamation in the criminal law. Well, and I think that I'm not saying that defamation should disappear as a form of illegal content, but I think that it is disproportionate to have defamation as a crime. This is something that would need to be addressed using civil law mechanisms, not criminal law.
It's a compares with other countries then.
Yeah, it's. I mean, there are many countries, unfortunately, they still have, let's say, defamation in the penal code. But the Inter-American Court of Human Rights and the Inter-American Commission on Human Rights has been very clear that according to international law, states have the obligation to decriminalize defamation. Also, the fact that special protections are granted to public officials in cases of defamation, it is also something that is problematic. No, because also according to, and here I'm not presenting my personal opinion, but I'm trying to make my arguments based on international law, international human rights law. What it says is that public officials need to show a higher level of tolerance vis-a-vis criticism, because otherwise, if you have specific provisions that introduce particular or more severe penalties in cases where you attack a politician, then of course the risk is you might be using these criminal provisions to target political speech. And we need to understand that political speech, political criticism can go very far, even to a point that we may feel uncomfortable, but it can go very far. But of course, there's also a limit. The limit would be incitement to hatred, direct incitement to violence. There we would find the limit. But something that the European Court, just to use the terminology of the European Court of Human Rights from many years ago, and this is something that then has been incorporated into other, let's say, international documents, the right to freedom of expression includes the right to shock, to disturb, and to offend. 3 very strong verbs. You have the right to shock, to disturb, and to offend. What you don't have the right is to violate rights. That would be step further. No, but you can be controversial and you still be protected. You can be offensive to a certain extent, and you're still protected under the freedom of expression clause.
So changing from the criminal law to civil law means that sanctions would be not imprisonment? Or?
Of course not. Yes, okay. Yes. And then also, this means that you'll never have a criminal record.
Okay.
Which is also very important. Maybe you don't go to jail, but you still have a criminal record.
Sure.
So also, I'd like to insist on the fact that even within the context of civil law or civil, redress mechanisms, there are also limits, meaning that you cannot say that, okay, this person defamed me, so I have the right to get $1 million. No, because then, of course, it's an indirect way to, for example, to force basically closing down the media outlet. So there, the principle of proportionality should also be respected, no? So that you don't impose on a small media outlet the obligation to pay a huge sum of money. It's more, about, for example, the judge ordering the publication of the decision, or the judge ordering that the person who made a certain statement then makes a different statement saying, okay, I was wrong, what I said was not correct. There was a judge that told me that, that was defamation, so I shouldn't be doing this. So I would like to say that the reputation of this person should remain intact, something like that. No, not just putting someone in jail, because at the end of the day, even if you are attacked in your reputation, the fact that you send someone to jail doesn't give your reputation back. You need to find effective redress mechanisms, ways that basically, kind of redress, help you get your reputation back. And this is, the correction, the apology, the publication of the court decision can be more effective than sending someone to jail.
Now, there's an inquiry in the Supreme Court opened 6 years ago regarding fake news and not yet finished. Do you have an assessment on this?
Well, this is basically about, let's say, the Marco Civil. It's an article in the Marco Civil that says that if you, in order to ask a platform to take down a piece of content, you need to have a court decision. You cannot just knock on the door of a platform and ask the platform to take down a piece of content. This principle, this is not something that was invented in Brazil. This is called the principle of intermediary liability exemptions. Basically, this means that if you are a platform that is hosting content, you are not legally responsible for the content that you are hosting. Those who are responsible are those who posted the content. No? So if I publish something on Facebook that is defamatory, it's going to be my responsibility, not the responsibility of Facebook. Why do we have this principle that is also protected under human rights system? Because that's the best way to protect the right to freedom of expression online. Why? Because if I tell a platform, you from now on you're liable, you're responsible for everything that you're hosting, the platform then will decide to err on the side of caution. They say everything that looks suspicious to me, I'll just take it down. Because, of course, if you are telling me that I might be responsible for everything that I host, then I will be the one taking down everything that looks suspicious to me. And also, this means that we are privatizing the decision of whether something is legal or illegal. It's not the judge anymore. It's not the competent authority. It is a private company that takes the decision. So, and this is what, in a way, this is about. It's too far-fetched to, let's say, ask an individual to go before a court in order to obtain a decision so that you can go before a platform, or whether this is a good protection so that platforms are not forced to take legal determinations. This is what is being basically discussed before the Supreme Court. I would say that the intermediary liability principle, the intermediary liability exemption principle, I think that it deserves to be maintained. But this doesn't mean that the Marco Civil, the Internet, could introduce additional, let's say, obligations for platforms to deal with illegal content. For example, there are some cases where if the content is manifestly illegal, then perhaps you don't need a court decision to take something down. But here we're talking about cases where the illegality of the content should be very clear, something that anyone can assess. For example, if we're talking about defamation, I think that we still need a court decision, because I don't want a court to decide whether something is defamatory or not, when you have two sides saying, you defamed me, no, I didn't, that was free, etc. So this is where, the bulk of the discussion, I think, let me put it this way, I don't think this is a matter of black and white, in the sense that, we need to get rid of Article 19, etc. I think that Article 19 is still useful, it is necessary for determinations that we don't want platforms to do. And there are determinations that probably we don't want platforms to do. We still want a judge to decide on certain matters. And then we can say that for other matters, platforms perhaps need to accept other obligations that now they don't have. And for example, in the European model, these obligations, now there's a new law called the Digital Services Act in the European Union that says, for example, you platforms now, for example, you have no new obligations. You still are not liable for third-party content, but you have new obligations. For example, one of these obligations is that if you have terms of service, they need to be very clear. If you take down a piece of content, you need to tell the user why you took down the piece of content. If you receive from a third party a notification about a piece of content that it is illegal, if this is a notification that contains a solid legal, let's say, explanation, then if you don't take that content down, you may become liable, for example. And other obligations that now platforms have, for example, to assess the risks that they generate and to mitigate the risks that they generate, for example. So I think that would be the way. I think that my personal view of this case is that I don't believe that Article 19 is unconstitutional in this sense. It's still important and relevant for the reasons that I already mentioned. But on the other hand, I think that either the court or the legislator can consider the possibility of introducing new obligations for platforms in order to be more transparent, more accountable, and also to work better, to do better when it comes to assessing risks and preventing risks with good internal and, say, changing sometimes their own design, their procedures, and the way they take decisions.
Still in this inquiry in the Supreme Court, there has been a lot of criticism because it is an inquiry originated in the Supreme Court, so there was no the prosecutors or the police that initiated that. On the other hand, the length is considered too long. It has been there for 6 years and it's still there, it's still open. So regarding those two aspects, can you comment on this?
Yeah, I think that what the British say, justice delayed is justice denied. So it's always good. I mean, when we have a pending decision, let's say, I mean, that for too long, it is never good because it creates legal uncertainty for everyone, not only for platforms, but for everyone. And of course opens the door to speculation, to pressure, to etc. It's true that, I mean, the whole process was interrupted by the pandemic, and I can tell you that in the first person, because I was at some point invited to testify in this case, and then this was interrupted because of the pandemic, and then I filed a written submission where I basically expressed what I just told you. I mean, to be honest, then it was decided that they would only consult with national experts, which is totally fine. But I think that in any case, and then of course, we had the legislators saying that they also want to intervene in this case, but now seems that the legislator is waiting for the court. I mean, these kind of dynamics, of course, they are not good. I mean, what is good and necessary in a field as important as freedom of expression is to have legal certainty. So in this sense, I think it would be good to have a decision as soon as possible. And the other element that you mentioned was,
and the fact that it was originated in the Supreme Court.
Oh, yeah.
Without.
That is more of a procedural issue that, I mean, I don't want to, because I'm not that familiar with Brazilian law, and I don't want to. I think that it's true, that it's in some cases courts decide on the basis of conflict, and in other cases courts ask themselves relevant questions, when they see that it is worth asking a question from a constitutional perspective. So in this sense, that's the legitimacy of the court. And I also understand that in Brazil, the Supreme Court has a very wide space to operate compared to other courts in other jurisdictions. So,
is it good or bad?
I mean, for me, it sounds. I mean, it sounds particular, let's say, because this kind of, that in some countries there's also this fear of judges going too far and judges taking decisions that are political. So you also, I mean, if there's always the risk of the politicization of the judiciary in a context like this one, of course, this risk becomes very, very relevant. To what extent the Supreme Court has been politicized is something that I don't have the elements to answer. But of course, this is in these cases, I mean, the independence, preserving the independence of the court and the justices becomes fundamental, for the credibility of the court, and So in this sense, I mean, I can also say that I may agree or disagree with some of the decisions or some of the statements already made by different judges of the court, but my feeling is that they are all independent. Of course, they have their own opinions about things, no? But I don't believe that they are not independent, no? They're trying to do their best or to try to formulate the best decision based on their honest understanding of the law, no? Which is, of course, what we need to have in any country.
So, Mr. Barata, what improvements do you think Brazilian courts and lawmakers should do to favor and guarantee freedom of speech?
Well, I think that, as I said, I think that we need to eliminate from the criminal law, any possible provision that can be used to put pressure on journalists and media. That would be one thing, and in this sense, I think that some improvement can be made, no, so that we get rid of the criminal prosecutions against journalists. That is clear. The second thing is that, it's a piece of advice that I would apply to any country, that it's very important not only to consider, let's say, the national level or the constitution, but to look into the decisions of bodies like the Inter-American Court of Human Rights, because they have very solid jurisprudence that could be very useful in Brazil also to better protect freedom of expression. And when it comes to the decision in question, I think it has to be adopted as soon as possible, I believe, or at least we need to have clarity as soon as possible. And I think, as I said, that, the best possible outcome would be to declare that Article 19 is constitutional. I believe it is not only constitutional, but it is aligned with international human rights standards of freedom of expression, but also perhaps then consider introducing some new elements, new obligations for platforms so that they become more accountable, more transparent, more fair, and they better protect the users. Because I think that here we have room for improvement.
Could you talk a little about your visit to Brazil? What's the purpose of it?
Yes.
What was it sponsored by some company or directly by the think tank you work for? How was it?
Yeah, no, I worked for a think tank that is called the Future Free Speech, which is in Vanderbilt University. And this is part of this is part of a trip that I did last week. I was in the Dominican Republic, invited by a think tank that is called Funglode, where I had also some discussions in this field, that is freedom of expression, because also in the Dominican Republic there's a discussion on these matters. And this was a visit where I had meetings with civil society organizations, and today I had an event that was hosted by a platform called Plateau Brazil. This event had the support of Google, and that is something that was basically, you could see that in the let's say everywhere. During the event, Plateau.br, let's say, supported by Google. No, those who took care of, let's say, the arrangements of my visit, my interlocutors were at Plateau.br. But it's public, and I think it's good that it's public, that this event was supported by Google, the same way that I participate at events that are supported by either other platforms, or I work a lot also with UNESCO. So in my case, I'm always happy, in as much as my academic independence is respected, and in this case it was respected. I'm happy to participate in different events supported by different donors. I would like to be 100% clear when it comes to this.
What is your assessment on big tech relations with governments?
Well, this is, let's say the relationship between big corporations, any big corporation, and any government is always a very, very sensitive one. No, but because of course, any big corporation, particularly those who have power in the field of communications, they may have the power to kind of talk to governments in a way that ordinary citizens are not able to. So that's the first thing. The same happened with traditional media. So we know that in this country there were big media conglomerates that, of course, had special access or the capacity to lobby vis-a-vis governments. No, so that is something that is obvious, and also happens in other industries. What I think is important, of course, is that there's this relationship is handled in a transparent manner. And for example, if there's a discussion on platform regulation, of course, platforms need to be invited to this discussion, but you also need to invite civil society. You need to invite traditional media. You need to invite activists. You need to invite journalists, etc. Also, I think the fact that platforms are involved in these kind of discussions, I think that, of course, they are an interested party, the same way that there are other parties that are also interested. That's one thing. The other thing, of course, is that I think that platforms need to remain independent from governments, the same way that big media companies or any media company needs to remain independent from the government. And of course, we see, perhaps not in Brazil, but in places and in the world, for example, in the United States, etc., we see that, there's this game of, the government trying to put pressure on platforms, but also platforms trying to put pressure on governments, or platforms at some point trying to be friendly to governments. I think that these kind of relationships are never good in democracy. They are very hard to avoid, but the only way to fight them is by having clear rules of the game, transparency, and proper regulation. No, everything that goes, let's say, beyond, or behind closed doors, that is not good, particularly when it affects something as important as the right to freedom of expression.
Joan Barata, thank you for this interview to Poder 360.
Thank you, and thank you for your questions. It was an interesting conversation. Thank you very much.
Agradeço também a todos os web espectadores que assistiram este programa. Esta entrevista foi gravada no estúdio do Poder 360 em Brasília, em 15 de abril de 2025. Para ficar sempre bem informado, inscreva-se no canal do Poder 360, ative as notificações e não perca nenhuma informação relevante. Muito obrigado e até a próxima.